So this is a recording of more litigation that has gone on in the candidate debate on debates. Who gets to get into the U.S. Senate debates in Minnesota? Can I get in, go face-to-face with Al Franken, or isn't that in the script? So anyway, 2 days ago, I filed a petition with the Minnesota Supreme Court as an elections petition. And yesterday, based on that, in part, based on that, plus I filed a new motion. And this motion is for an injunction, temporary or preliminary, to get into the debate, which is tomorrow morning at 10 o'clock. Thankfully, because of the circumstances, I just heard from the FCC on the 20th and had problems with his computer, as you might be able to tell. My motion was accepted yesterday by the Supreme Court. They've appointed 2 new judges. Some people have not taken any part in this. This is at the Minnesota Supreme Court. And today we got a response from Mr. John Borger from Faegre and Benson on behalf of CBS, the New York broadcaster who wants to come into Minnesota and decide that we should not include Independence Party people. Apparently they did in part rely on Larry Jacobs, the famous political expert from the University of Minnesota, which, by the way, is a state operation. So that's basically, it does have now elements of the First Amendment as far as state actors who are cutting off the First Amendment rights. But this goes far beyond that. So what I want to do right now is to read for you, what did CBS say? And the reason I want to present this is not only to inform you on the progress of this race, but because this is almost a universal practice. Well, here in Minnesota, we've established the Minnesota Independence Party as a major Minnesota party. And the way you get to be nominated is you sign up for the primary. Now, if you don't have opposition, you're going to get in the primary. And there are people who do that, and I've done that in the past. This is the first time that I went into a state primary. I won that primary. I got the nomination. And before that election, with the interference of the large parties and the small party, I was polling 13% against Al Franken and Mike McFadden, which was already above the threshold required by the Larry Jacobs standard. And Hannah Nicollet polled 11%, and therefore she was admitted on that basis. But that is not really the crux of the response. It's just something that they threw in for CBS's benefit. Now I'm going to read to you what they actually said. CBS Broadcasting Incorporated, which owns and operates television station WCCO-TV, respectfully requests that this court immediately reject Stephen Carlson's petition as directed against CBS. Carlson is seeking an order of this court to mandate his inclusion in a debate between United States senatorial candidates Al Franken and Mike McFadden. And after all, I'm not Al Franken or Mike McFadden. And it's scheduled for this Sunday, October 26, 2014 at 10 a.m. Or he's asking that the debate not be broadcast at all. Could still be held, but not benefit from the public broadcasting facility of CBS and WCCO. And so CBS submits this motion pursuant to Rule 127 of the Civil Appellate Procedure, and they go on. So here's to their arguments. They talk about third parties. Although Carlson invokes the jurisdiction of this court under Minnesota Statutes 204B.44, that section does not support any claim against members of the news media, such as CBS. Claims against such private third parties are not appropriate under Minnesota's election laws. And he references this case, Darris versus Higgins. Now, I'm going to reply, and you're going to see that that's totally inappropriate. So here's my response. This submission is limited to a reply to CBS and the other parties involved in excluding me from the debate tomorrow, WCCO, TV, CBS, Al Franken, for U.S. Senate campaign, Mike McFadden for U.S. Senate campaign, Hubert Humphrey Institute of Public Affairs, who excluded me, I guess, supplied some intellectual criteria. I will file a separate reply to the motion to dismiss by Mr. Borger, and actually I'm going to file a response. Now, replying simply to what Mr. Borger has raised in response and not even reading or responding to his 127 motion at this time, then comparing the Darris case to this one is inappropriate for several reasons. First, that case was brought after the election and as an election contest under Minnesota Statutes 209 and is inapplicable to this case. CBS here, further, is not a third party. It is an entity charged with duties concerning this election. By holding and broadcasting one of the 3 publicly broadcast debates in this federal election for U.S. Senate, purportedly, the U.S. Senate candidate debate, they say, that's not how they describe it. They describe it as between Franken and McFadden. CBS has taken on some duties statutorily. Now, in addition, this debate is part of the election itself. This is not commentary by the voice of CBS. This is a debate representing to the voters of Minnesota to be the views and statements, in short, political expression of the U.S. Senate candidates themselves. They have censored out my voice from that debate in the interest of exercising their own First Amendment rights, which I recognize and respect, but totally disregarding mine. As I have already said in the motion, there is a profound national commitment to having these debates, this very debate which CBS and the other entities involved, and this does not involve Mark Ritchie or the State Canvassing Board as respondents, as I believe the petition itself makes clear, that these entities must, under the First Amendment precedents of the U.S. Supreme Court, as stated in Buckley versus Vallejo and set forth in the petition, the debate tomorrow must, as a duty charged to CBS and the broadcasting media, be, quote, robust, uninhibited, and wide open, unquote. It's not wide open if CBS chooses to ignore the primary elections which nominated us and box out one of the candidates. That's closed, not wide open. It may be robust as between Mr. McFadden and Senator Franken, but it surely will not be robust on my part. And the whole point of this motion, as stated, I'm sorry, I can't cut that part out, and the whole point is stated in this motion, as stated in the memorandum, is that I be able to express my views in comparison to the other 2 major nominees, major party nominees, who are legally indistinguishable. I'm legally indistinguishable from McFadden and Franken, and that the voters/viewers, because when they watch this debate on CBS, they're not merely viewing CBS programming, they're voting, which is why CBS's responsibilities, duties, are different than, say, broadcasting a soap opera or Saturday Night Live. These voters get to know, to be informed about what my views are, what my opponent's views and our qualifications are, so that they may consider that when they vote. Not allowing me to even appear on my behalf is like trying me for a crime and only letting the lawyers, the prosecutors, appear and argue. This is my argument, and that is why it is formally, this is my argument. I get to make my argument here as in a case. That's why it's formally moderated. In addition, CBS and the 2 opponent candidates wish to exclude me to give the Franken and McFadden campaigns more exposure, more legitimacy, and more advantages, and as we shall see, to nullify the primary which I won. The voters will be left not knowing what a free and fair election might have yielded, and as the Buckley court said, one of us will go on to make substantive law that this court and Mr. Borger and the other lawyers will busily enforce. It will bind me and everyone else. Clearly, there is a big distinction between a soap opera and a formal, solemn election for the U.S. Senate to constitute and reestablish a new federal government. The only interest CBS has in this is its First Amendment right to carry its own views on political issues to the voters, so that the government will not control its own elections, to be an outside entity that will transmit to the voters what my views and information is. And CBS is saying it has no duty, no interest, or obligation in doing this. This is the opposite of what the First Amendment provides. They, like the Star Tribune in the Darris case, unlike the Star Tribune in the Darris case, are not a third party. They are part of the process of free and fair elections, and they are created as well as bound by the First Amendment. Let me just make clear what I just said. The Star Tribune, when it reports, or whatever it did in the Darris case, put a picture in its paper, whatever it did, yeah, it played a part in the elections. Okay. But they did not carry the actual views of the candidates. It was not a candidate debate. From what I understand, it was probably an advertisement or something. But they were a third party. But they exist because of the First Amendment. But their role there was different than this. And what I'm going to say is that we have mutual responsibilities under the First Amendment when you're actually broadcasting a campaign debate. If you're just writing a story about the campaign, you have a right because that's your views. But if you make money by going in and making yourself part of that very voter selection process in the electronic media, this powerful electronic media, you have a different role than the Star Tribune did, just carrying an advertisement. And again, this is something which John Darris brought up after that election was over. That was an elections contest. This is the election that is going to happen on November 4th, and I'm forced to make this a part of that election. So CBS, in this response, consistently confuses its own First Amendment rights with my First Amendment rights, which they disregard, and they claim to have no duty. They also misrepresent the voters/viewers as having no First Amendment rights or voting rights, which they must respect, CBS, as if their goal is to entertain the voters, not inform them, and to misrepresent the candidates to them. And I disagree that they are a private person. And here's why I'm saying they now claim that they're a private person. Here's CBS arguing again. Carlson simply has no legal basis for any claim against CBS, or indeed any other private person engaged in First Amendment activities such as news coverage and debate or candidate forum arrangements. And now they seem to be arguing that all they're doing here is arranging a debate. Well, they're arranging to broadcast a debate, and they're broadcasting the debate, and as we shall see, equal time does apply here. But here's where they say they're a private person. Now then they go on, and we get into this whole thing with Larry Jacobs. They start to attack me, saying a minor party, fringe, and unsuccessful. Well, the election's still on. Unsuccessful candidates for public office uniformly have failed to present legally cognizable claims seeking to force their inclusion or to recover damages or other relief for lack of attention in debates and news coverage. Well, first of all, this is not about news coverage. This is about a debate. You getting to see what my issues are as opposed to Franken's or McFadden's, which now I do by these movies. And so this is where he talks about private persons with First Amendment. So I say I disagree that they are a private person or private entity here. The same First Amendment which they rely on to protect them against this court or the government infringing so that they can present their views. Remember, they're talking about freedom of the press here. We're not talking about freedom of private persons. So Mr. Borger is deliberately confusing this matter. Freedom of the press is all that we're talking about with the broadcast media. And the same First Amendment also confers on them that a duty to exercise that right. And that right is freedom of the press. It is the freedom to present their views about the election. And I have no problem with their presenting their views. Their view, apparently, according to their lawyer, I don't know if they would broadcast this, is that if someone has less than 10% in some poll, that therefore they would be able to throw them out. That's their view, and they're broadcasting that. But that doesn't make it the law. Their view doesn't make it the law. Larry Jacobs' view doesn't make it the law. Okay, and so the real First Amendment, freedom of the press, confers on them a duty to exercise that freedom of the press right, respecting the First Amendment rights of others. In other words, they do not exercise that free and independent of every other private American, because we're all part of the government. We're all the people. And they have a special role, and candidates and nominees have a special role, and I guess parties have a big role too, don't they? Now, the First Amendment is not merely some kind of franchise for CBS's corporation or licensed by the government to make money programming and broadcasting. They are very much in the electoral process themselves and cannot stand outside it. They cannot avail themselves of the protections of the First Amendment or of this court without being bound by the concomitant duties, the duties that go along with those that they commit themselves to in this process, to include a major party nominee. So they can't assert their own rights to say that I have none. Now, again, CBS is accusing me of being a fringe candidate, minor party candidate, even unsuccessful. But if I am put next to Al Franken and Mike McFadden and convey to the voters tomorrow that I have better qualifications, better views, and conduct myself better in policymaking based on my debate, I will be successful by definition. And CBS cannot know this in advance. And if the voters for some reason say, well, Carlson clearly won the debate, but my heart belongs to Al or Mike, then there is their freedom as well. And our government has to take that risk, that voters will base their votes on whatever they choose, not subject to the government's scrutiny. Further, let me correct CBS. The Minnesota Independence Party is a major party. It's not a minor party. They talk about minor party. That does not apply here. We're legally indistinguishable from the DFL of Senator Franken or the Republicans of Mike McFadden. This court, being a Minnesota court, should embrace Minnesota laws and give them effect, and allowing an out-of-state commercial broadcaster to come into the state and pick and choose our officials in Washington by overruling the statute which creates the right of the Independence Party as a major party to hold a primary and put a candidate on the ballot. Negating our law in this way would not be appropriate for this Minnesota Supreme Court, and CBS should respect that. I am defending my nomination in this case because it does not belong to me alone. It belongs to the Independence Party and to the independent voters who chose to vote with that party and reject the DFL and Republican primaries in order to vote for me. And they expect my views to be considered by all the voters in the election. The Libertarian candidate did not win a primary. The Forbes case is inapplicable here because Forbes did not assert his right to equal time with the FCC. And they go on to cite the Forbes case, however, to say that I don't have a private right of action. That's what they actually go on to say. I can't even bring this. But their last statement about minor party, fringe, and unsuccessful candidates is led with Arkansas Education Television Commission versus Forbes. This is a U.S. Supreme Court case, which is very, very different from this. But they talk about a state court noting that a candidate's inability to show popular support of at least 5% in an independent state poll was a reasonable and viewpoint-neutral basis for exclusion. Well, here I've shown 13% in the Gravis marketing poll. That's higher than 5%, and I put that, CBS has a copy of that, they just choose to ignore it. Now, it doesn't say, even in that case, that every poll you have to go above 5%. But in reality, in the poll that I cited, it shows that of the people who have already voted, I'm getting 8% of those votes. And 51% voted for Franken, and I believe 38% voted for McFadden. And this is almost exactly their votes that they got in that previous Gravis marketing poll. So I don't think, and then it says further, besides that case, they claim that CBS may set its own appropriate threshold of voting polling preferences that it wishes for participation in its events. and it, in consultation with Larry Jacobs of the Humphrey Institute, has determined Carlson has not passed its threshold of candidates supported by 10% of likely voters in credible recent polls. So are they saying that Gravis Marketing isn't credible? CBS, their poll is credible, their ideas are credible, but Gravis Marketing on Huffington Post, that's not credible. And this is, they can come in here and they can broadcast this all over the country, enforcing the Democrat-Republican duopoly. And Al Franken's working for that. Now, Carlson's reference to equal time provisions likewise has no merit. There is no private cause of action to enforce 47 U.S.C. 315, and it cites Forbes versus Arkansas Educational Television Commission, Network Foundation, etc. By the way, that was an Eighth Circuit case. But the Supreme Court, not the Eighth Circuit, addressed that. And I will get to that, but let me go back to what I'm arguing in my reply. Forbes is inapplicable here because Forbes did not assert his right to equal time with the FCC. He did not exhaust administrative remedies. I did assert it, and I attached it, and Mr. Borger for CBS has not questioned that. I am not comparable to Forbes. He chooses his own poll. I have submitted the Gravis poll showing me at 13% against Franken and McFadden in the general election, which is higher than Larry Jacobs' threshold. Larry. I guess Larry didn't know about that poll. Or he doesn't think it's credible. He's credible, but not Gravis Marketing, who does polls all around the country. The IP's Anna Nicollet, in entering a governor's debate in Moorhead, was also subject to this threshold, and the same poll, Gravis, showed her at 11% and was used to allow her in. I do not see presented by CBS any case in which that determined that the major party status, not talking about minor party, fringe party, unsuccessful people, but the major party status does not need to be respected in making a determination such as this. I guess Larry Jacobs and the University of Minnesota have made this determination. And like, you'll remember what Al Franken said when he was at Farm Fest. He said, if you don't believe I'm going to win, just go ask Larry Jacobs. Larry Jacobs is his good buddy, his authority, who promotes Al Franken. Excuse me. Now, the whole purpose of creating the Independence Party and the law establishing them and their rights was to allow the people to bring up a party against these huge national parties, the Republicans and the Democrats, during elections, and being treated with the dignity and respect of presenting a third choice. And I submit that this is what McFadden and Franken want to eliminate, a third choice to them. So Mr. McFadden says he'll repeal Obamacare. And Franken says, well, you can make that choice, but if you do, you'll lose your coverage. Many, many people will lose coverage. This is an example of a stark two-party choice that CBS or NBC allow to be put to our voters, limiting our freedom, forcing a choice between two parties who each feel entitled to power, as Al Nicollet has said. The power is with the people, and our actions in establishing these legal procedures for elections should be respected as the U.S. Constitution itself respects it. It puts the power to elect the senator in the hands of election by the people through the state laws we establish, not by CBS's ideas. And those laws cannot properly be ignored by CBS or even this court, especially when this court shares the profound national commitment that debates be robust, uninhibited, and wide open, unquote. Mr. Jacobs and the state, and the University of Minnesota is the state of Minnesota, take away my First Amendment rights by calling me fringe, unsuccessful, and negating a primary election. Doing what they do is not wide open. So it's not wide open if you take away my First Amendment rights because I'm fringe and unsuccessful and you negate a primary election. That's not wide open. It does inhibit the viewpoints I presented to the voters when I won a statewide election. Because as I said, they're different. It's a third choice. Mr. Borger misstates Forbes, as I said, and documented in my petition and motion. The Forbes court noted specifically that Mr. Forbes had given up his right to enforce the equal time provision because he failed to exhaust his administrative remedies and never found that no private right exists. That's completely false. I don't know how Faegre and Benson can come up with this. Because even if, as they say, the Eighth Circuit ruled there's no private right of action, and apparently this was appealed to the Supreme Court in that one sentence overruled that aspect of the Eighth Circuit. Because they said the reason was not that it doesn't exist. That's totally, I think, off the charts. It's ridiculous. But they said he never asserted it. But I did. Now, with respect to debates being all documentaries, and let me go on with what they're saying about that. So let's go to what they say about equal time after the private right of action. In other words, private right of action, you may have that right, but you can't bring it to court yourself. You know, maybe the FCC commissioner will have to bring it, or Barack Obama will have to bring it. Al Franken might have to make a recommendation. But in fact, there is that obvious private right of action, which has never been gainsaid by the Supreme Court. And he said that what these people now, CBS argues, the petition itself represents that the federal communications discussion has refused to take any action, Carlson's complaint to that body. So I did file a complaint to that body. That exhausted administrative remedies. When they refuse to take action, that is the remedy that is available there. It's been exhausted. I now proceed to the courts. And then they go on and say that A1 through 4 of the equal time, which is the so-called exceptions, expressly exempts bona fide newscasts, news interviews, news documentaries, and on-the-spot coverage of bona fide news events. Now I ask you, am I challenging any of that? Am I saying that CBS, as long as they apply by the equal time provision, do not have the right to do their bona fide newscast, their news interview, their news documentary, or on-the-spot coverage? No, I'm fine with doing that. And then they say, including but not limited to political conventions and activities incidental thereto. This is not a political convention. It's not a CBS Broadcasters convention. This is a debate. And they say debates, even when sponsored by broadcasters, are considered bona fide news events under those statutory exemptions. Well, that apparently is, he cites an FCC 1983 decision of them. But this isn't the FCC. And I submit that, as a matter of fact, I don't know what happened in the Geller case or the Latto case, but that this is not those cases. This is a very different case in which the state of Minnesota has to make some decisions about its elections laws. And this is not controlled by the FCC. As I mentioned, the Constitution itself gives this power to the state by its elections laws. It does not give it to the FCC. And so the CBS concludes the court should deny Carlson's motion, dismiss the petition, and remove any cloud from the imminent event on WCCO TV. That's tomorrow's debate. No clouds. Okay, so let me finish my reply to their response. And all of this was filed with the Minnesota Supreme Court this afternoon. I had to file my reply in about an hour or so. And it's very difficult for me because I am not a lawyer. So, again, with respect to debates being all documentaries, and again, I have limited time and can provide more cases and expand on this argument if the court allows, I do not see any of these exceptions, which he listed, of the equal time requirement that says debates are accepted. Certain debates, yes. Perhaps if, portions of the debates, but it does not say debates are accepted. I don't know where in there they find that. But what is at the heart of the program broadcast is a political election campaign debate, clothed in the expectations of the voters and viewers and the duties of the broadcasters to allow the candidates to be heard. It's no different if they don't allow me to be heard than if in the middle of the debate they say, Mr. McFadden, you're going to have to leave. We're going to just let Al Franken answer the rest of these questions. There's absolutely no difference. I don't think there's been a case like that. I don't know if Mike McFadden would sue them for that. But I've never heard of them doing that. But they're basically censoring me, and they can't censor those other two. They can't censor any of us because what they're providing is their facilities. This is nothing about their programs, but this is the use of their facilities. They can use it too, but we're using it for the debate. That's what the law says, that you don't have to make your facility, what you have as a facility, you don't need to make it available to any political candidate. That means that that candidate is availing themselves of it, they're using it. We use it too, not just them. The people use it too, and not just the soap opera company. All right. So I think that if what is at the heart of the program broadcast is the election campaign debate, clothed in these expectations, and notwithstanding their own right and duty to express their ideas, then I don't think the debate is merely incidental to their programming, and they must get out of its way and allow the laws of the state of Minnesota designating in all elections major parties, and in this specific election, major parties and primaries to work. And I want to just clarify that because I typed this very quickly. These laws of the state of Minnesota designate in all elections major parties. And in this specific election, it also designates major parties and primaries, and they have to be allowed to work. CBS cannot impose on them. CBS is imposing Larry Jacobs and his thresholds as a super primary, a super elite, Larry Jacobs, super elite, who quiets debate and prevents robust, uninhibited, and wide open debates in our Minnesota elections. CBS has not argued that I failed to show the Dahlberg equities weighing in my favor, and my motion for injunction should be granted because the equities do weigh in my favor, despite these arguments presented by CBS. I respectfully submit or ask that this court lift this cloud from my candidacy, my party, and this solemn election of the people of Minnesota for U.S. governor, and that you enjoin CBS to admit me because of the likelihood of my prevailing on this in the full proceeding. Further, it will not hurt CBS, and they have shown no right to rely on this threshold of Larry Jacobs. They just assert it. I don't find that that presents injury to them, that they're not allowed to assert this very arbitrary so-called threshold as a reason to deny me equal time. So this I presented to you as briefly as I can so that you can have a chance to see what has to go on behind the scenes, behind that debate, behind that curtain. And I'm hoping at this point that the Supreme Court will rule in my favor and allow me in tomorrow. Otherwise, I will be continuing to press this point. And I also will be continuing to try to get into the NPR debate next week, even though those people, Mike Mulcahy, Tom Scheck, have shown real hostility to my viewpoints, and they distort them, they twist them, and they actually broadcast lies about me. And so I believe that, well, of course, if they do that, why would they allow me in their debate if it's their decision to make under equal time? I'm Steve Carlson, and I will continue with this, and I hope to see you in the debate on Sunday morning. Thanks for watching.